We are not going to have a bomb go off after the countdown. Hi, everyone. I'm Molly Foley-Healy. I see a lot of faces from all the other classes we did before the pandemic hit us. It is so good to be back in Aspen. I've missed you all. I feel like many of you are like my HoA family up here, and it's just so good to be back. So I talked to Cindy about what do we want to cover. This is our first seminar in at least 3 years. And I thought we would kind of start with kind of fundamental governance in HOAs and talk about some dysfunction that's occurring in HOAs. Anybody have any dysfunction? No? All right. So we're going to talk about governance and how to make HOAs a better place to live, because they weren't so great during the pandemic and after. People had a lot of issues. And so for those of you who don't know me, I'm Molly Foley-Healy. I'm an attorney who specializes in HOA law. I've been in this job, dealing with HOAs for 16 years in Colorado. And so I've probably seen it all. I've had some new experiences lately. So it takes a lot to surprise me. But I want to talk about governance today, and then Cindy and I are going to look at another seminar in September, October. Keep your eye out. We're going to talk about major changes in the law in terms of enforcement of covenants and rules and collections. The law is really different than what your governing document's saying. It's all going to trump it. So anyhow, let's start with fiduciary duty of directors. How many of you serve on a board of your HOAs? Okay. How many of you are in a condo association? Mostly yeah. Any single family home projects? Okay, just a few. We have a lot more condo projects up here, especially A.P.C.H.A communities. So I'll kind of speak to both of those as we go along. But what I wanted to talk about was basic governance for directors and boards, and also talk about interplay in with that responsibilities of homeowners to make communities a good place too. So it's not just a board issue. So directors of HOAs have a fiduciary duty to the association. And that means they have a duty of care to the association. We'll get into that specifically. They owe a duty of loyalty to the association. And they're also required to act within their scope of their authority. So you don't have to raise your hand for this. But I hope every director here never goes to an HOA board meeting without their governing documents. Because if you are not having your governing documents with you, you're breaching your fiduciary duty because you don't know what you're required to comply with, okay? So I'm going to talk about governing documents in a little bit, but Cindy, can you hit duty of care? Okay, so yes.
Quick question. What if you have online internet access to the docs while they're doing?
Oh, that's fine. As long as you don't have to have them in paper form. We do not need to kill trees. Electronic access is fine. We just need to be able to look at them when they're relevant to what decisions boards are making. Okay, can everyone hear me okay? Awesome. All right, so I'm an old codger, and when I was in law school, they talked about the duty of care. They called it the reasonable man. You know, you have the duty of care like any reasonable man in a similar position. In the HOA context, we don't use reasonable man anymore. And I won't make bad jokes about men and reasonableness. But anyhow, you as directors, you have a duty of care to act as directors of other like communities would. Okay? So you're not required to have the same knowledge I do because I specialize in community association law, but those governing documents are going to be a very big guiding component for you. So a duty of care requires the director. I've got all these screens. I'm trying to decide which one to look at. It requires you to act with the care of an ordinary prudent director. So how anybody, you know, that's on a board of an HOA in Aspen, Colorado, you have similar duties of care, okay? So, and always, folks, if I can hammer something home in terms of fiduciary duty, it's you must act in the best interests of the association, okay? And what does that mean? It means the association is a corporate entity, but here's how I always explain it to my clients. It means that you have to balance the interests of the association with the individual owners. And the association as a corporate entity in the interests of all the owners as a whole is typically going to, guide what your governance is and your decisions. And then you have to act in good faith. So, does anyone have a pain in the rear end in their association? More than one? More than one? Every HOA does. I know of no HOA that doesn't have at least one. But here's the thing, in good faith means you're not going to look at those people and punish them because they're a pain to deal with, right? This is what I do for a living. I know how much there are times I want to just make their life miserable because they've made everybody else's life miserable. But as directors, you can't do that. You can't allow those things to guide your governance. Okay, you can. All right, the duty of loyalty. So, fulfilling the duty of care. Okay. I'm sorry. Yes, I'm sorry, fulfilling the duty of care. So how do you do that? I want to say everybody's having board meetings. Yes. Regular board meetings, maybe once a quarter. What's that?
Appropriate time every quarter.
Yeah.
Every 6 weeks, which is too long.
Yeah. It depends what your bylaws say. Your bylaws may say you have to, have a quarterly meeting, or you might need to meet twice a year. Depending on how complex your project is, your community association, and what you have going on in your association is really going to determine how often you need to meet. I would say in most condo projects that you need to be meeting quarterly, because you're going to be looking at things like, are people paying their assessments? Do we have any maintenance responsibilities in terms of common elements that are problematic? Things like that, and you can't be on top of those if you're not meeting. Yes?
I just want to clarify, so when you say board meetings, is that just with the board members or with the whole community?
Okay, so there's two types of meetings in an HOA. There's meetings of the board of directors, and that's where they're governing the community. Just as an FYI, board meetings, unless there's an executive session, are open to the members, okay? The other types of meetings are meetings of the members, and that's an annual meeting typically. You may have a separate budget ratification meeting, and those are meetings that you call of the members, where members elect directors at your annual meeting. They may do budget ratification at the annual meeting, or you may hold a special meeting of the members for that purpose. Okay, so boards, I would say as a rule of thumb, unless you've got really complex things going on in the association, or unless your bylaws require monthly meetings, I would say at least quarterly. Okay? But if you've got construction going on, if you have major issues in the association, monthly meetings are a good thing too. Okay? Yes?
Just real quick, that could be an online meeting where we
Yes.
meet like by email.
Yeah. Well, not email. That's not a meeting.
Okay, but Zoom.
Zoom. So the question is, can you meet online? So the Nonprofit Act applies here, and the Nonprofit Act says as long as the board can hear each other, and I would say also obviously speak to each other, you can hold a board meeting electronically, and membership meetings too. All right, and as a matter of fact, I was chatting with some of the folks here at the beginning. With the pandemic, all of a sudden Zoom meetings became the way many of my associations meet. And, the pandemic, thank you, Lord, is pretty much over now. But most of my clients have stuck with Zoom meetings because I think they found that they're just convenient. You don't have to come together, some of my boards like to meet in person, and that's fine too. But as long as you can hear each other, speak with each other, and communicate, that's fine. Also, board meetings are open to the members, okay? So members also need to be able to connect electronically if that's how you're holding your meetings, all right?
Members of the neighborhood.
Members of the association.
You know, the problem with Zoom is we have a 3-minute time period to voice our opinion or our
Right.
problems at the end of the meeting. If our
Open forum.
Metro board doesn't like it, they'll put you on mute.
They mute you? Yeah. So let's talk about members attending board meetings and what their legal authority is. Okay, so traditionally, board meetings have open forums, right? So the members get to speak. A lot of times it's at the end of the meeting. And do all of you have a conduct of meetings policy? It's required by Colorado law. And the conduct of meetings policy, it's one of the 9 responsible governance policies. And that is where you're probably getting the 3-minute, you get an opportunity to speak for 3 minutes. In addition to open forum, which is not a legal requirement, but it's just normally kind of traditional in associations, owners have the authority to speak prior to the board making formal action at a board meeting. So somebody makes a motion, the motion is seconded, the board discusses it. Prior to the board voting, under the Colorado Common Interest Ownership Act, we call it CIOA, CCIOA, that's the state statute that regulates HOAs. An equal number of owners are permitted to speak for or against the motion before the board votes, okay? So don't use the open forum as a way to cut off people from speaking before the board votes, because they have that legal authorization.
We're never allowed to talk or address their voting on something
Okay.
until
They,
it's too late. They've already decided, we have no input.
yeah.
Now it's too late.
So, and that probably is because if they don't have legal counsel or they haven't been to training, they may not even know that statutory right exists for homeowners, okay? So just let them know Colorado law allows us to speak to it. But again, it's for a specified period of time. And, the chair of the meeting is permitted to say, we're gonna have 3 owners speak for the motion and 3 against, okay? So, but let me make one thing clear about member participation in board meetings. Board meetings are business meetings of the association. It's for the purpose of conducting business, and owners have a right to be there to watch the deliberations and to hear what's going on in their association. The fact that homeowners have a right to speak before a vote occurs, or the right to speak at an open forum, does not mean they have a right to interrupt the deliberations of a meeting. And I don't know if you've been at those meetings, but as legal counsel, I want to leap from a bridge when that happens, because it's like we have 15 people who are on the board instead of the actual board making deliberations and having the owners here and giving them at appropriate times the authority to provide input. So let's not confuse the statutory right to speak with to interrupt the deliberations or the work of the board. Yes?
So, I know the common thought is, you have 3 minutes to make your case, so to speak, which usually is never enough. But what is the obligation of the board to actually discuss and address the issue? Not that you just state what the issue is or what you have an issue with, but to actually discuss that particular topic. or
Okay,
that
so during an
particular-
open forum, when somebody brings an issue to the board, what is the authority or the requirements of the board to actually, or to have to respond to an owner? They don't have a requirement to, okay? And if it's a new issue, And this is not being disrespectful to owners, but if it's a new issue that they need to do due diligence on and investigate and look into, I tell my boards, do not give them an answer because you don't have enough information to do it at that point. So I like to see open forums used as the ability to determine, are there issues in my community and what we need to be putting on the agenda for future meetings and we need to be looking into and addressing. So there may be some things that they can just answer, but if it's a new issue, if it's a problematic issue, I want my boards to be doing their due diligence before they make an answer, because if they don't, a lot of times they're going to give a wrong answer. And a lot of times the answer is based on the governing documents. So if they don't have those available and they are not consulting them, they could be giving wrong answers that I have to come in as legal counsel for my clients and clean up. Okay? And I'd rather not clean stuff up. Yes?
So just out of curiosity, how, when the board members meet, how are they supposed to let homeowners know that they're meeting? Like, for example, if somebody wanted to attend the meeting, how would they?
Okay, so that's a great question. How do owners know there's a board meeting? So what I recommend is after the annual meeting, when the directors are elected each year, that the board meet and determine a schedule for regular board meetings. And then if you have a website, you post it. If you have a newsletter, you can say, these are the times we're going to meet. And then, but interestingly, under state law, there's no requirement to provide owners with notice of a board meeting. So I suspect that will change at some point. But good governance says schedule your meetings and put them out there so people know when your regular meetings are going to happen, and then just let people know. If people ask, let them know. When you yes, so that's a great point. So even though state law, Kiowa does not say you have to provide notice of board meetings, your bylaws may. Your declaration is probably not going to address that, but your bylaws may. And frankly, it's good governance to let people know there's meetings. And I encourage that strongly. Yes, I'm just going to take I'm going to take these two questions and then move on.
Presentation. There is a division between Kiowa applicable HOAs and non-participating, i.e. small HOAs that were formed before a certain year who elected or voted not to participate or follow the Kiowa rules. I'm curious to know how many HOAs
that's
are in that category.
Kind of right, okay? All right, so the Colorado Common Interest Ownership Act became effective law on July 1st of 1992. HOAs were the declaration, the governing document was recorded prior to that date, I call pre-Kiowa communities. And there's several provisions of Kiowa which apply to pre-Kiowa communities, and there's other provisions like the insurance provisions and things like that that do not apply to pre-Kiowa communities. For pre-Kiowa communities, unless you go through a statutory process to opt into all provisions of Kiowa, which I typically don't recommend my clients do, because there's some benefits of not having all components of Kiowa apply to you. Then only those provisions of the Act which apply to pre-Kiowa communities are going to apply to communities created before July 1st of 1992. However, all of what I call in the last 10 years, there's been a lot of legislative changes. I call it kind of HOA, Homeowner Bill of Rights, kinds of provisions of Kiowa. All of those provisions apply to pre-Kiowa communities. So most of the provisions that you're dealing with in terms of governance are going to apply to all HOAs. Any community where the declaration was originally recorded on or after July 1st of 1992, all of Kiowa applies, okay? So I want to move on because we got, oh yes, I'm sorry.
Really quick question. Molly, isn't there a requirement under Kiowa that if you request your board to provide notice to you of board meetings specifically, that then they
Electronically, yes. If you ask for electronic notice of special meetings, yes. Yep.
Say Kyle again, what it is what?
The Colorado Common Interest Ownership Act, CCIOA, okay? It's not like the town in Colorado.
No.
All right, so fulfilling your duty of care, attend meetings. You know, be prepared for meetings. I'm hoping agendas are going out before meetings so you know what you're gonna discuss. How many of you are self-managed HOAs? You don't have a manager? Okay. How many of you have a manager? Okay, less, because a lot of you are A.P.C.H.A communities that are pretty small, right? So you're probably don't have manager. You're gonna need to do agendas. For those of you who are self-managed, do you have a bookkeeper that handles your financials for you? Okay. Wow, that's some serious, you do? That's some serious volunteer work if you don't. So anyhow, you know, you're gonna need to be prepared, and the agenda is a good place to start. What issues are you gonna be considering at the meeting? I don't know if you've ever been to these meetings where they beat a dead horse, never make a decision, and do the same thing the next meeting. Have you ever been to those? Yeah, and nobody ever makes a decision because they don't have the information they need to make a good decision. And so that's why it's so important to be prepared to get the information you need to really consider the items on the agenda so that you're not beating a dead horse. And I mean, I've had clients that put off a simple decision for, 8 months because they go round in circles and talk in circles, and they don't have the information they need to finally make a decision. So be prepared. Ask questions. If you have stuff going on, and I know a lot of your communities have roof replacements going on, major renovations, you might have common element issues that you're dealing with, please ask for expert advice. The beauty of asking for expert advice, engineers, contractors, people like that, is you as directors are insulated from liability when you rely upon the advice of experts. Okay? So, all right, this is not me suggesting anybody be religious, but I happen to get talked into I'm an Episcopalian, being on the vestry of my church. And I live in a master association, and nobody knows it where I live. It's kind of my place where I don't have to talk HOAs. And I'm not embarrassed to say I don't go to meetings because, it's what I do, and I don't want to deal with it at home. And I always said I never serve on an HOA board because that's what I do for a living, right? Well, I'm on an HOA board for my church. It is exactly like being on an HOA board. We're talking about putting solar panels on, and I was at a board meeting last night, and these guys are yelling at each other, and I'm really sick of it because none of them knew what they were talking about. And I'm like, why don't we get an expert in here to talk about it? Because I can tell us, none of us know what we're talking about here. So we're just wasting each other's times. Have you been at those meetings? Yes?
You had said get expert opinion.
If you need it.
If you need, let's just say you want to get roof done.
Right.
How many opinions should you get? How many estimates? How many, what
Okay,
what is
so the question is, let's say we have a roofing project, which seems to be big right now, right? How many bids do you need in order to make a decision on a contractor? First of all, if you're just getting an opinion on whether you need a new roof or if you can fix it, or if you need a new, membrane or whatever for the roof, you can just ask a contractor you trust to provide you with that opinion. Depending on what kind of work you're doing and the availability of contractors, and I have a lot of clients in this area, and I know contractors up here are really difficult to get right now. It's really hard. Depending on the number of contracts, I always like to have at least 2 bids. 3 is nice, 2 is good. But look for things like, are they a trusted roofing company. I'm not wild about roofing companies. No offense if anyone's a roofer, because I've dealt with a lot of issues with them. Do they have a decent contract? What are their warrants? So you're looking at a whole bunch of things when you're talking with roofers. A lot of HOAs, you have people with expertise living in your community you may not know about. You may have an engineer that lives in your community that can give you good advice. You may have a general contractor that can give you good advice. So, look within your community when you're looking for information on issues. Yes?
So with regards to that, though, I thought I read something, though, if somebody, say, for example, you have a contractor in your building, are you allowed to hire that? I mean, you can get advice.
I'm going to talk about conflicts of interest in just a bit. Okay? Yes?
I'm sorry, can I introduce myself really quick? I'm with CORE, the Community Office of Resource
Hi.
Efficiency, and we offer free service for all you guys.
Yay.
So a lot of you are needing some energy efficiency upgrades, new roofs. We're a free service. I have a one-pager. We have rebates and grants. Like in Pitkin County, you can get up to $50,000 in grant for your homeowner association. So we're really here to help you guys. We know a lot of the buildings are, a lot of the equipment's
Yep.
getting at end of life. So you can come see
Yay.
me afterwards and I'll give you the sheet and how to get hold of us.
Thank you. Thank you. All right. Yes?
Yeah.
So what if you get expert advice and choose not to follow it? What happens? I mean, that's my life, right? I give advice to my clients all the time. If they don't like it, they're going to do what they're going to do. If you don't follow the advice of not only legal counsel, but whatever experts, maybe it's a CPA, an engineer, any of those types of people, you're not required to follow the advice, but you don't have the protections you do when you follow the advice of an expert, okay? I always say to my colleagues who are knocking their head against the wall, I say, you can lead a horse to water. After a while, you give them your best advice, and they're either going to listen to you or not. So. What if the advice is expensive? Well, yeah. Yeah, and with smaller HO, so the question is, what happens if the advice you get from experts is really expensive and you can't afford it? So you look for other solutions. So you as a board, members of boards have what's called the right to exercise your business judgment. And so when you're looking at alternatives, like let's say you need, a new roof because you're having water intrusion and you can't afford it now, you might look at, well, what are options? Can we do some repairs until we get the capital necessary to do it? Do we need to look at a loan? So really, here's one thing with common elements that I really recommend. Please try not to defer maintenance, okay? And I see that a lot in the association world where you've got, especially with self-managed small associations, nobody wants to increase assessments, right? Because they're your neighbors. And so as a result, I've run into a lot of situations with smaller communities where there's not enough money in the association to cover basic items. And the problem with deferred maintenance is the useful remaining life, if you're deferring the maintenance, the useful remaining life of components that the association is required for is a lot shorter. And you're going to have large expenses. So we're going to talk a little bit about budgeting, but when you're budgeting, you got to be real, guys. And I'm not going to ask for hands. I don't want anyone to say, well, the assessments are $200 a quarter, and you've never prepared a budget to base your assessments on. That's a breach of fiduciary duty, because your budget is the expenses of the association and the income you need to make your expenses. which includes regular maintenance, so you're not deferring the maintenance, and the roof and the siding and other components you're responsible are not lasting as long. So these are tough decisions to make. And did I hear, maybe not from you, are you gonna be doing more reserve studies potentially in the future? Okay, those reserve studies are a really important tool. So if A.P.C.H.A is gonna work with you to do updated or new reserve studies, a reserve study is nothing more than a budgeting tool, okay? You're not required 100% reserve for components the association's responsible for, but those reserve studies are so important, and people get stressed out with them because they find out, well, the roof really only has 5 years left. Or, you know, other major components the association's responsible for. But those reserve studies give you really good information on how you need to be budgeting to make sure that you're keeping the useful life, the remaining useful life, at its longest term, and you're budgeting appropriately. So when you do have to do a major replacement, you have the funds. Or you get a loan or other options. We can talk about that in another class. All right, let's go to duty of loyalty.
Wait a sec, one question. The attending meetings, if those guys on your board don't go to meetings, or how many can they skip before you go, hey, you know, you don't have enough interest, you need to go do something else?
Well, if you're not going to meetings, you're not carrying out your fiduciary duty.
Right.
And, you know, there are things where people can't get to meetings. So I'm not saying there's a magic number.
Yeah.
Stuff happens, right? But if you're on the board and you do not ever attend meetings and that happens, then, you know, you're breaching your fiduciary duty to the association. So you need to routinely attend board meetings and participate in the deliberations of the board.
One other, this exercise independent judgment, what if the president comes on Zoom drunk?
You know what? I don't want to get into specifics for any community because, all right, let me just set the ground rules. I don't want to talk specifically about any project. So when I'm giving these classes, I'm talking generally about good governance. I will tell you this. Before the pandemic, and I went to a bunch of meetings, I mean, I'd go to 3-4 meetings a week with boards, and they'd offer me a glass of wine, hospitality, very nice. I don't ever drink at a meeting when I'm working. And boards need to be, you know, sober to do their deliberations. That's all I will say on the subject. Yes, and then I really need to move on.
Anybody needs any other, there's a lot of great information on the DORA website.
Is there?
Which is the Kiowa.
Yep.
You can get all the answers to your questions.
Be careful, they're not experts. I didn't say that on GrassRoots TV, did I? All right, duty of loyalty. So remember, as directors, you have a duty to of loyalty to the association as a whole, to the best interest of the association. And it's hard, especially if you're in a smaller, self-managed community and your neighbors meet you at the mailbox or go into your unit after work. You can't base decisions of the board to benefit an individual, a neighbor, a family member. You've got to act in the best interest of the community. And that sometimes can be really hard. You know, especially if you're looking at potential special assessments or other things the association needs. You know, it's really hard when you're self-managed. So, but remember, your duty is to the association as a whole. Fulfilling that duty. All right. First of all, I want my boards as much as possible, and I understand it's 2023. And everybody does things in text and email. But I don't want you governing the community electronically. I want you, especially if there's really important issues you're looking at, significant issues, I want you to get together and talk about it and make sure you have all the information you need to make a good decision. I see people just whipping back and forth with emails all the time, and there's a few problems with that. First of all of those, when you're making decisions via email, all of those emails are records of the association under Colorado law, which owners have the right to inspect. So if you're doing that, you better either have a manager or somebody on the board who's capturing all of those email communications. And as a lawyer, I'm paid to be paranoid. If you get sued, everything in those emails is going to be discoverable, okay? And I know for a fact, because I've dealt with it, people say stuff in emails you would never say in an open meeting, right? And it can come back and bite people in litigation. I've also had courts seize computers to make sure that they have somebody forensically go in and pull all the documents from it if you get in a litigation. And I want to be clear, litigation's rare in associations, okay? But just know, the other thing from a transparency and governance perspective, the owners don't have any ability to watch the deliberations of the board to see if you're acting in the best interest of the association or to provide you with any input. So try, unless it's an emergency, try to get out of the habit of governing your community via email, okay? Those are not open okay. So we're back to meetings. Maybe I should do a class just on meetings. That's okay. So Kiowa doesn't define meetings. Can you believe it? And so what those of us in the industry who specialize in this, we have, and it's been this way for years, we advise our clients that meetings are when the board meets to formally transact business of the association and to make decisions. So I have clients all the time, they're looking at a major capital improvement, and they're gathering information, they're just talking to potential contractors. Those are not meetings. You're not making formal decisions, you're gathering information. So you don't need minutes of those meetings, and those are not open. If you have a disgruntled homeowner, they will argue they are, and we'll go round and round and round with them, but they're not meetings.
Yeah, that was just to the point of people tend to do it electronically.
Mm-hmm.
I think because some people think anytime you get your board members together, it has to be open.
Right.
So
well, okay, let me say this. The sunshine laws for municipalities do not apply to HOAs. We have our own set of rules in Kiowa about open meetings, okay? So I hear that all the time, especially up here for some reason. A couple of the directors met at the mailbox. That was a meeting. I'm like, no, sunshine laws don't apply. That may be true for municipalities, but those do not apply to us, okay? You know what, Cindy? Maybe we just need to do meetings. I mean, because it's really important. There's a ton of law in Colorado on meetings for HOAs. Okay. So I want you at board meetings, electronically or in person, when you're really working through hard issues, I want you to passionately debate it in a professional way. You know, we don't need to personally attack one another, which, believe it or not, happens occasionally at an HOA meeting. Permit the owners, you need to make sure the owners have the ability to provide their input either during open forum or always prior to the board voting on an issue. And once a decision is made, and I've been hardcore about this with my clients, I represent an active adult community down in the Front Range with a golf course, and 400 owners came to my board training. And I was talking about fiduciary duty. And once the board makes a decision, as a director, you cannot go out and undermine that decision in the community. You owe a duty of loyalty to the association, okay? And I had one of the directors say, well, we go out after golf and we talk about it, and I said, if you feel the need to, you know, try to undermine decisions of the board while you're having cocktails after golf, that's fine. resign from the board. Okay? So once the board takes action, makes a decision, you don't have to go get your pom-poms and be a cheerleader over this, but you can't actively undermine a decision that the board made. And if you feel the need to do that, you need to resign from the board. I'm just straight up about it, okay? All right, the next one is handling conflicts of interest appropriately. All right, of the 9 responsible governance policies I talked about, one of them is a conflicts of interest policy. So every HOA needs a conflict of interest policy, okay? I'm gonna talk generally about conflicts of interest. I never know which screen to look at. So I'm gonna talk generally about conflicts of interest, but this is a perception issue too, okay? So conflicts of interest means when a director, you're living in your association, right? And a director has an interest that that the other directors or other members don't. So for instance, let's say you live in a attached townhome, and let's say there's 12 townhomes, and you've got someone smoking weed, and it's coming into your unit, or they're loud and they're a problem, and you're taking enforcement action. The director who made that complaint about their neighbor has an interest that is different than everybody else in the community because they are directly affected by it, okay? So when that happens, they can speak as a homeowner on this enforcement issue, but they shouldn't be acting as a director, okay? So that's when you as a director have a different interest on an issue than the rest of the board or the community. And it's usually enforcement, guys. Or that dog is pooping in my yard, you know, that kind of stuff. All right, so conflicting interest transaction is another component of conflicts of interest. This comes from the Nonprofit Act. And a conflicting interest transaction means a contract, transaction, or financial relationship between the association and a director, between the association and a family member or a person related to a director, or the association and an entity in which the director is also a director or has some financial interest in the entity. So let me explain. I'm on the board of my HOA. Smack me if I ever do that. But I take my hat off to you guys. Let's say my husband owns a landscaping company, and my husband wants to get the contract for my HOA. I would have a conflicting interest transaction because Larry is related to me, and he wants to get a contract with my HOA, and I'm on the board, okay? Let's say I own the land. Let's say I'm a bookkeeper. I see this up here a lot, okay? And I'm getting paid to handle the bookkeeping for my association. That's a conflict of interest, a conflicting interest transaction. Well, it's legally permissible. I prefer, if you're on the board, you're getting paid for bookkeeping or managing. I've also had some communities up here where a member of the board ended up managing and was getting paid for that. I'd rather have you get off the board, get paid for your services, and there wouldn't be any question of a conflict of interest, okay? So it's hard with self-managed communities. Yes? Would that apply to an officer that's not on the board as well? An officer of what? An officer's typically on the board. Well, that's weird. Okay, so the question is, what if it doesn't have to be though. An officer doesn't have to be on the board. So the question is, what happens if an officer of the association has that kind of issue? I would say the conflicts of interest would also apply to that person. Sometimes, so let's talk about the difference between directors and officers, okay? Directors are members of the board who are elected by the members. So the board can never remove, members of the board. The members of the community elect the directors in most cases. Okay? Well, I'll tell you when they don't, when there's a vacancy. Okay? So typically, members elect directors. If a director resigns and there's a vacancy on the board, typically the bylaws will say, in Colorado law provides, that the remaining directors, even if there's not quorum, have the ability to appoint someone to fill the remaining term of that director. So those are directors. Officers are going to be designated in your bylaws, and that's typically the president, sometimes a vice president. The three, though, that we normally see: president, secretary, treasurer. Okay? And they are appointed or elected by the board. Colorado law does not require that officers be members of the association, but many bylaws do. And typically they are. Okay? Usually you see in large-scale projects, you might see that the secretary is somebody who's not on the board. Okay? Because they come in and they do the minutes and all that. Treasurer might not be somebody on the board. So there's a difference. Members are the only people who can remove directors, but the directors may remove an officer. But if they do that, and they're still a member of the board that was elected by the members, you can't remove them from the board. Does that make any sense? So whoever elected or appointed gets the removal piece. That's kind of a general rule of thumb. Okay? Wow, are we getting off on all sorts of stuff? But it's good. Okay.
So are officers ones that the board brings in?
The board typically appoints the officers, yes.
And an officer is what?
The officer is the president of the board, the treasurer, and secretary. Sometimes there's vice presidents. But they only have the authority designated in the bylaws, okay? Or the authority that the board delegated to them by action of the board. So we're like way in the weeds here. So I want to get back to conflicts of interest. Okay, go to the next slide. All right, so here's some basic rules on dealing with conflicts of interest. Never give a loan to a board member. I think that's pretty, the association shouldn't do that. That's pretty basic, right? So when there's a director has a conflict of interest or a conflicting interest transaction, generally speaking, the director should always disclose that at a meeting of the board before there's any action on the conflict. So let's say my husband owns a landscaping company, wants a landscaping contract from my HoA. Before we talk about that, I as a director would have to say, my husband, Lawrence Healy, owns a landscaping company, and I have a conflict of interest, okay? Okay. If somebody doesn't declare a conflict of interest and somebody on the board knows there's one, that person on the board, that director, should disclose that conflict of interest. And you know what? Be professional, be nice, but Molly, doesn't your husband own that company? So, okay, so here's the preferred approach of taking action upon a disclosure of a conflict. And this is what I draft in my conflict of interest policies for my clients. The director who has the conflict during that board meeting can be counted as present for purposes of establishing a quorum. However, once the disclosure is made, I don't want that director participating in discussions with the board. They can participate as any other vendor would and say, here's why I'm a great landscaping company, here's how much it is. But once that's done, I want them to excuse themselves and leave the room. Because I don't want the perception that I got it or my husband got that contract because I'm on the board. Okay?
Partial recusal?
What's that?
So it's like a partial recusal?
It's full recusal.
Full recusal.
Yeah. And then the other thing I don't ever want is the person with the conflict to vote on the issue at hand. That's where the underlying conflict is. Is that required by Colorado law? No, but it's good governance, and it's going to stop a nightmare. So let's go on to the next. That's what I draft into my policies. All right. I hear a million times, they didn't disclose that conflict, so that contract is void. It's not valid. That's not how Colorado law works, okay? The transaction is not invalid solely because the transaction involves a director, a person related to the director, an entity that the director has a conflict or has an interest in financially. So that doesn't mean the contract is invalid, okay? It's not invalid either under Colorado law if the director's present at the meeting and actually participates in the discussions of the board. So legally, that doesn't make it invalid. And the conflicting transaction is disclosed or normed before the transaction is approved by the disinterested directors. So let's say you don't have quorum if that director recuses himself or herself, they can still make that. If they made that decision without quorum, it's still not invalid. Here's the key with transactions where there's a conflict of interest. As long as the conflicting transaction is fair to the association, it is not invalid. So let's say I didn't disclose it. I didn't disclose that Larry has a landscaping company. He got the contract, and it was the most financially reasonable contract, and he does great work. The fact that I didn't disclose it is crappy governance, and I should resign from the board, but it doesn't make that contract invalid, okay? So what's really key is if the contract is unfair to the association, like you got completely taken to the cleaners on the cost, then there's an argument that it's invalid. So here's what I want you to know about conflicts of interest. Perception is reality. If you've got conflicts of interest going, I will guarantee you homeowners, understandably in this case, are going to think you're up to something. They are. Look, that was her husband, man. He just made, 30 grand from the association. What a racket. Maybe I should get on the board because my wife has got this company that does X. Conflicts of interest and conflicting interest transactions are going to make you guys look bad. So avoid them. And if I really wanted Larry to get the contract, I either go disclose it and not participate in the discussions of the vote, or if it's a really big one, a massive amount, maybe resign from the board. That's just a concept. Okay. All right, one big thing for directors. You only have the duty to act within the scope of the authority that you have. Your declaration, it's a condominium declaration for condos. It's usually called a declaration of covenants, conditions, and restrictions for single family home communities. Same stuff. In there's going to be an article that talks about the authority, the powers and duties of the board. And it's going to specify all of your authority. A lot of times it's also in your bylaws. So check that out. Sometimes the bylaws and the declaration, powers and authority aren't exactly in sync. So remember, the declaration, if there's inconsistent provisions in the bylaws, the declaration is going to trump that. Yes?
I'm just confused because on our board, we just have a president, vice president, treasurer, secretary.
They're also directors.
Okay.
Yeah. So your articles of incorporation may have some powers of the association, but your bylaws and your declaration will. And just a pet peeve for me, it's called a declaration, singular and not plural. That's just, does anyone have like a little thing that's like fingernails on the chalkboard? That's mine. So there's also authority of boards in the Colorado Common Interest Ownership Act, and then most HOAs are nonprofit corporation, and there's authority in that act too. What I think I might do is get that to Cindy, or I'll blog on it and provide a link and you guys can see it on our blog. Yes?
Question in regards to authority then. So you have the Articles of Incorporation bylaws and the declaration.
There you go.
I got that right, but is there a hierarchy? I've heard there is a hierarchy.
Yes, there
if
is.
there's conflicting information in
Yep.
those documents, which
Yes,
unless
there
it
is.
says one is above another.
Yep. Yes, there is a hierarchy of documents. So sometimes your articles, declaration, and bylaws might have slightly different provisions. So the highest in the hierarchy of documents is the Articles of Incorporation. But that usually doesn't have much in it, really. It's what just creates the association and requires you to have a board, okay? The next highest, the most important governing document, in my opinion, in any association is the declaration, okay? That is exceedingly important. The declaration is going to cover things like not only authority of the board, but it's going to cover maintenance responsibilities, insurance responsibilities, use restrictions on the common elements, use restrictions in the unit, and that's the document I really want you all to have and to be looking at in board meetings. The bylaws deal with the governance components of the association. So really the declaration is all the administrative and operations. The bylaws are going to talk about governance, unless you've got really old ones that have use restrictions in them. I find that up here. Or collections. But typically bylaws are how boards are elected, how many members of the board, terms, who has officers, the requirement to hold an annual meeting, proper notice, all of those things. So that's how the community is governed. Is going to be covered by your bylaws.
Where do you usually find rules and regulations?
Okay, you just ask if the association has any, okay? So the declaration is always recorded with the clerk and recorder of the county where the association is created. And any amendments, and any condominium or plat map is recorded. The bylaws, sometimes they'll record it and I'm like, why? You're not required to, don't. But bylaws are a document of the association, and rules and regulations, including policies, are also documents of the association, so you just ask for those documents, and you as owners have rights to those documents. Okay, so if you get requests for documents, how many days? Kiowa says, section 317, that you have to get a written request, and you need a records inspection policy. It's one of those 9, okay? And there's only very specific documents which are records of the association which have to be produced, okay? But assuming they do a written request and are specific about the documents they are looking for, you either have 10 days, or if the board meeting is held within 30 days from the request, you can give them to them at that meeting for inspection. Okay? And there's nothing, well, if they don't provide them, there's could be a penalty. You know, here's my pet peeve. Sometimes owners are just angry, and especially in a self-managed association, they will ask for every document known to mankind from the association just because they're mad, and they do nothing with it. And these volunteer boards, particularly the secretary, is like in the garage going through boxes, looking for minutes 20 years ago or whatever. But if they don't, there can be a penalty for that, and you should, talk to, it sounds like you have an association with some issues, governance issues. They probably need to come to training. Because a lot of times I find, especially with self-managed communities, they aren't complying on purpose. They're not trying to be a jerk. They just don't know. I mean, they don't carry Kiowa around in their pocket. You know, they may not even know what Kiowa is. So it's a matter of, you know, that's where the DORA division of real estate is good. The HoA information office, you can grab something off that and show them. But it's problematic, yes.
Our declaration and governing documents are over 30 years old. At any point, should we update them, or?
They're an antique.
Yes, they are. We made pre-Kiowa.
You pre-Kiowa?
2 months.
Okay, so the beauty of being pre-Kiowa is you'll never be a Kiowa community, even if you update the documents, unless you opt into them. So I have tons of clients up here. Now, I have some documents from the 60s. They're so bad, you know? But the problem is the amendment provisions make it impossible to amend them. And I'm actually working with a state legislator to try to fix that. But if they're 30 years old, so the 90s, you know, some of those aren't bad documents. So you don't necessarily need a rewrite, but if you've got problematic provisions, you may need to do limited amendments just to fix it. So here's what you need to know about Kiowa in the declaration in particularly. Kiowa is going to trump inconsistent provisions of your declaration. But unless you're a geek like me who knows what Kiowa says, you don't know. And that's the beauty of having more up-to-date documents. They're more in compliance with modern law. So, you know, I'd have someone look at it and just say, does it need to be? I'm not an attorney who's like, I want to rewrite everybody's declaration if it's not necessary. So, but if they're really antiquated or there's provisions that are problematic, insurance is a big one for me. So in condo projects, a lot of the old documents require the association to carry all-in property insurance coverage on units. That's really expensive. So all-in property insurance coverage is everything in the unit except personal property and window treatments is covered by the association's property insurance coverage. So I do a lot of amendments on insurance to bring it down to bare walls or original construction to get your insurance obligations down. So things like that I would look at. Did you? And oh, did I? Yeah, or maintenance. What's that?
Lindsay helped us with that.
Oh, good, good.
Okay.
Yes.
Where I'm a little confusion is apparently there was a new House bill that was passed in August.
2 years ago. It went into effect August 10th, 2022. It's HB 1137, House Bill 1137. It's awful.
But it said that everybody, they have to update to the current.
No, there's no law in the books. There's nothing in Kiowa that says that you have to bring your documents into compliance with Colorado law. Your collections policy and enforcement policy need to be updated to comply with law, but not the declaration. Okay, so that's different. The declaration is never required under Colorado law to be updated every time the law changes, but if you have policies that the law affects, then you need to update those policies. So enforcement and collections are huge, guys. If you have old policies, the laws completely change.
Just a quick one. If you were going to change just one, like a section in your bylaws, how would you go about that? Someone grandfathered in a vehicle and we don't.
Okay, so that's probably your declaration, not your bylaws. And I'm not saying this to try to make money, and I'm not suggesting me. Get a lawyer to help you with that. Because there are, well, you know.
We just bothered to address it.
Yeah, but if something in the declaration needs to be addressed, remember, boards have the obligation to enforce the governing documents, and owners have the obligation to comply with them. And when I say owners, I'm also saying directors, okay? So directors are also owners, and they need to comply with the documents too. But I've seen people with great intentions thinking they're doing an amendment right, and it kind of becomes a mess. So I recommend if you're gonna do an amendment to fix something, that you get a lawyer to help you out with it. Yeah.
And amendments to the declaration probably should be recorded.
Oh, they must be to be effective.
So what if you have an old condo association, they had amendments and they didn't record them?
Then they're not effective. Yeah. Bylaws, nothing's recorded with bylaws, but the declaration. Deck amendments only become effective upon being recorded with the clerk and recorder. For us, it would be Pitkin County. Yes.
With the new law regarding like enforcement and like collecting fees and late fees and stuff like that, if you're acting within the scope of the new law, but you don't change your condo declarations to reflect that, like,
Oh, yeah, you don't have to amend your declaration to be compliant, but you need a policy that's compliant. And I will guarantee you, so my law firm, all we do is HOA law, and we're all specialists. And when that law came down, I have never seen a worse written piece of stuff in my life. And I was senior vice president and general counsel for Community Associations Institute and National Trade, and I lobbied HOA bills. I've seen thousands of HOA bills. That is the worst piece of junk I have ever seen. And we sat down around a table for hours trying to interpret what it meant. We didn't know. We had no idea. And so we started talking with the other firms that specialize in HOA law, and we all came together and said, okay, this is what we think this means. But I can tell you, if you don't have a compliant collections policy, I'm guaranteeing you you're not complying with the requirements to collect delinquencies. There's all sorts of posting and notice requirements. There's 18-month payment plan requirements. There's tons of new requirements that are in the policy that's a lot. Don't even attempt to read that law. After hours of it, I was just like, I can't do it anymore. So collections and enforcement changed drastically on August 10th of 2022.
What's the name of the law?
It's called House Bill 22-1137. And everybody who's like me who specializes in HOA law usually quietly curses when we talk about it. Yes.
Just out of curiosity, in a certain situation, we had a lawyer advise that, because from what I understand from that that there's certain, like you just said, there's certain processes that they have to go through, offer payment plans, blah, blah, blah. But it also states in there that until they fulfill all the other duties, that they can't bring a foreclosure. And the attorney that we've gotten advice from apparently said that that was on the table, and my guess was that she doesn't really understand the law.
I don't know. I mean, the statute's pretty specific about foreclosures. And one of the things that changed in the law with 1137 is you can never foreclose for fines. Okay? And there's all sorts of notice. The board has to make a formal decision on foreclosure. There's tons and tons of, and you know, and that's to protect owners, right? Foreclosure should only be a last resort ever. But there's just tons of, you know, notice requirements. Like you have to post the notices of delinquency on a unit door. I have a unit that's going to be scraped and reconstructed. Nobody lives there. And I told the manager, run in, put the notice on the door, take a picture, and get out quickly, because it's dangerous, you know? So there's certified mail, return receipt requested. By the way, return receipt requested in there. Nobody in an HOA, whoever is in violation or delinquent, will ever sign for their. So, and the other one is regular US mail, and you can send it by email or text. I mean, it's just, yes. Yeah, I'm all for notice, but this law just went. And if somebody speaks a language and they can't read English, they can request that all notices be sent in that language. And you have to send all the notices in that language from there on out. And I mean, I've got one county in the Denver region where there's 150 languages spoken. And so our joke was, I'm going to ask for it in Klingon, you know. I don't know if it's been given yet in Klingon.
So basically, if somebody tries to foreclose or do something and hasn't updated that law or put a lien on a property, it's not valid because they haven't
Right.
followed the due process.
Yeah. But it's going to end up in litigation over the Yes.
So you can't foreclose on fines, but what about delinquent
Yes.
dues, homeowners' dues?
Yeah. You have to, when there's an assessment, we'll do a special class on this,
Yeah.
guys, because this is just, and you know what? I really want you to bring caffeine to that class because it's boring. But you have to give a notice and you have to deliver in all these ways. You have to give an opportunity at an 18-month payment plan. They have to default at least 3 times if they've accepted the payment plan before you can proceed. There's just all sorts of stuff. And you know, what we try to tell legislators was, like, really, assessment income is all associations have typically to cover their expenses. And so there's, you know, there's a really good happy medium in this bill, in my humble opinion, didn't reach that happy medium, because owners shouldn't lose their house easily. I mean, it's the biggest investment of our lifetime. So anyhow, there's
at 8%.
Yep, interest rates capped at 8%. Typically, most HOAs were 12 to 21%, some 18. So they changed that. Yeah, there's just a whole bunch of stuff. Can you hear me? Can you hear me now? Okay. All right. Examples of breach of fiduciary duty. I just want to power through the rest of this. And now, Cindy, we know what we need to do classes on.
Yes.
Okay, so here's some examples that can get boards into trouble, okay? And I don't want somebody taking this to their association and saying, see, you're in breach of fiduciary duty, but this is things that boards need to do. You know, if you don't maintain, repair and replace the common elements you're responsible for, and you don't plan for the common costs of that, you know, you can get into problems. And we talked about deferred maintenance being a huge problem in associations. Failure to plan for reserve items, and reserve items are those things that are like major repairs and replacements the association is responsible for. So that's going to be roofs, siding, asphalt, you know, drainage systems, under drains, sewer systems. I've got a client in the Front Range that's 50 years old. They've got 12 buildings, and all of their old sewage system pipes are just disintegrating. And it's not that they failed to do something, it's just their old pipes, and it's gonna be millions of dollars to fix it. So it's better to be on top of it and plan for things and not defer maintenance. All right, I wanna make sure, and I'm not asking for hands. Every year you need to be preparing a budget for the common expenses of the association. What it costs for snow removal, and I suspect nobody's budget was enough this last year for snow removal. Maintenance, repair, and replacement, normal maintenance responsibilities. Funding reserves to put money into the reserve fund for future major projects. Failure to collect assessment delinquencies. And I think, Cindy, you've probably seen this with A.P.C.H.A projects. Most of them are self-managed and your friends, right? And it's hard to do collections action on your neighbor, especially if you don't have a manager who can send the notices and that kind of stuff. But you have a fiduciary duty to collect assessment delinquencies. Protecting association funds, making sure they're deposited in accounts, that they're deposited in insured accounts. So I think the current account insurance is what, $250,000. So if you've got $5 million in one institution, you might want to find out talk with an advisor about where you should be putting your funds. Failure to enforce use restrictions, and then not enforcing your governing documents uniformly. So remember that PETA, the pain in the rear end I talked about earlier? Enforcing only against them because you can't stand them, but not enforcing the same things against other owners who are also violating. Okay, so these things can get you into trouble. You do have a protection. It's called the business judgment rule. If you're acting in good faith within your authority and you're exercising your honest business judgment, the business judgment rule is going to provide you with protections. Other protections for directors, because I don't want to scare you, because it's really, I've got to tell you, I've been practicing in Colorado 16 years. It's rare my clients get sued. It's rare. But you have directors and officers liability coverage that will give you a defense if you are. Okay? So D&O coverage is going to protect you. Also, your documents typically, your governing documents typically provide that the association has to indemnify directors. As long as you weren't grossly negligent or acting with willful and wanton misconduct, the association is going to indemnify you if you're sued.
So for this area, what is, I guess, a good D&O coverage amount?
Talk to your broker. They'll give you a good idea. And then the other thing that's going to protect you more than anything, governing in a transparent manner and having good communications with your members. You know, if you're being transparent and you listen to people and you treat them with respect, you're not going to have major problems. People want to be heard. So, off we go to dysfunction junction. You know, this is weird. It's weird to hold. So, when the pandemic hit, I thought, I'm going to get a little bit of a break. You know, I mean, people aren't going to have money to pay legal fees. You know, people are doing their own thing. The pandemic was my worst nightmare. And it might have been yours too, and I'll tell you why. People were home all the time. They were home all the time. They were sick of being home all the time. They were sick of their family. They were sick of their neighbors. And all of a sudden, they started looking for stuff. So they were finding fault for things that nobody ever, you know, would have thought about before. And you add that to the culture wars in the United States and to negative political campaigns and how people treat each other. And a lot of that I found in the last 4 or 5 years, and I'm not going to give you my political feelings, so don't worry. But it's made people really uncivil. Not only homeowners, but boards. And, you know, here I am, 59 at meetings, telling people who are older than me, do you remember what your mother taught you when you were young, or your dad? Do unto others. Treat each other the way you want to be treated. I'm telling people this because people now say, oh, that's just political correctness. And I'm like, no, treating people with human decency is not political correctness. It's just being a decent human being. But meetings have gotten contentious. So I want to give boards and owners tips for creating a better community. So let's say you've got a major project coming up that's going to cost a lot of money. Or something's going, let's say your water system is going on the, it's not working. What you need to do is to give owners a heads up early about issues. Communicate issues early, communicate regularly, keep them in the loop, let them know what's going on. There is nothing worse than levying a major special assessment, calling a meeting, and nobody knew about it. So, keep people informed. Hold open meetings. Do not do all your governance online, and be transparent. Because the one thing I hear over and over and over are people who are conspiracy theorists. And I know my boards are acting in the best interest of the association, but because they're doing it electronically or behind closed doors, nobody knows it. And so people jump to the worst conclusions. So, hold open meetings and be transparent. Give the owners the opportunity to speak before decisions are made. And listen to owners. Really listen to owners. Don't just twiddle your thumbs, flip through papers while they're talking. I mean, listen to them. You might not agree with them, but give them the respect of listening. Sometimes we have egos, right? Don't let your ego or your anger at somebody get in the way of doing what's right. And don't bully somebody because you don't like them. And that happens sometimes. If you're on a board and a director is doing that, quietly off to the side, talk to the director who does that. Have a conversation about it. And always, always, always act in the best interests of the association, okay? So we'll go to the next one. And we're almost done. Yes?
So when boards meet and they make a major decision that reflects one of the owners, are they required to have minutes of that decision, or?
Any formal decisions of the board either have to be in an action outside of a meeting that the bylaws permit, or they have to be in the minutes of the association. And actions taken outside of a board meeting need to be attached to the minutes of the next meeting of the board. Okay? All right, tips for homeowners, because it goes both ways. Be good neighbors. I'm amazed at how people mistreat each other, especially in a condominium project. They're loud, they're smoking weed, and they know that the smoke is migrating into the next unit, and they're not, getting a smokeless ash or whatever you need. I mean, just be decent to people who are your neighbors. Attend board meetings and stay informed. So one of my clients, I just got a letter they forwarded me to from their legal counsel. And this letter said, you are not keeping them in the loop, blah, 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 blah. You're not transparent. It's like they have discussed this issue for 2 years at every open board meeting. All of the information is on the website, and you weren't there. We can't drag you to these board meetings. But, so don't get on people when you are not attending board meetings and listening and going on the website if you have it to see what information is there. Don't jump to conclusions and assume the worst. That happens a lot in the HOA context. Now, admittedly, there's some bad boards. I'm not saying all boards are great. But a lot of times people jump to conclusions, and it usually happens, guys, because a board isn't doing their governing in a meeting. Yes?
So this kind of goes to, if you can't attend a meeting and you're reading minutes of that meeting, how detailed should minutes be? Because very often there's a reference to something that was discussed, but there's no detail.
How detailed should minutes be? As a lawyer, all I want my clients to do is put in the motion, the second, put in discussion ensued, and the vote. Minutes are not a transcript of everything that association, anything people said at the meeting. Some of my clients do really significant meetings, but honestly, Judy, that is like some legal liability out there sometimes.
You don't mind having something attributed to you, but they decide that that's not going to be part of the minutes.
Minutes.
He said, she said, kind of thing, if you don't have enough detail in the minutes to back back up the statement you just made.
My comment is, go to meetings.
I understand sometimes.
I know, but, you know, that's that push-pull, you know. Oh gosh, do you have pot stirrers on the board or as homeowners? Have you ever experienced that? I mean, they will think there's something going on and they will run to every neighbor and get them all revved up. Don't be a pot stirrer. Find out, get informed before you go there. You might have a great reason to talk to your neighbors about a concern, but don't pot stir unless you know you're accurate. And a lot of people jump to conclusions. Comply with the use restrictions and rules, and that includes board members, right? Because you're members too. Be part of the solution. Something that bothers me with all nonprofit boards are people go to meetings and berate volunteer board members for something, but they never give them like constructive solutions they would like to see. Instead, they Monday morning quarterback and berate. Be constructive. You know, give ideas, give input. And then, this is what I have to say. There's always those 2 or 3 people at every association who do nothing but disparage everybody on the board. Run for the board. If they're that bad, run for the board. But those people never want to run for the board. Sometimes they do. Also, serve on a committee. There's a lot of committee work that's done, especially in self-managed communities. Be part of your community and be part of the solution. And I'm not saying all homeowners are bad. They aren't by a long shot. You know, that's why associations exist, for the best interest of the community as a whole. But let's just be real with each other and treat each other with respect. So I think that is pretty, so the last 30 seconds. HOAs can be a great place to live or a nightmare. And we together as homeowners and boards can choose which place it's gonna be. And 90%, really, I'm serious, of my clients, they're good places to live. But that other 10%, we need to work together to fix it. So that's it. Thank you, A.P.C.H.A.
Thanks, Molly.
Yeah, I'll take some questions. Just pop them. But you can come up here.